House of Assembly or an election, perhaps the candidates chose not to challenge it. In the case of the governorship, the governor, from what I read in the papers, he had, and it's also in compliance with the Electoral Act, to have had agents at different polls. Because once the results are collated, your agents must also have, and as a candidate in the election, it is also your entitlement to also have the list of registered voters so that you can challenge it. And that's why I went further in saying that when you are challenging the result of an election, it is incumbent on you to produce that result, the original result. And so if he has done that, the first question that would then you now ask yourself is, how many registered voters you have in this particular area vis-a-vis the votes cast? If he was able to establish that for himself, he doesn't need to wait for any other person. And it is not the duty of the court to raise issues like this. What is the fact before? The court must not go beyond what is placed before it. So I don't want us to be sentimental or emotional. For me, I'm not, let me speak like Ozekome SAN2, I'm not a party-carrying, card-carrying member. I don't belong to any political party. I am not from Abia State. And so my being here is just simply as a friend of the house to look at it from that legal perspective, without more. So as far as I'm concerned, looking at it from that legal angle, I can't conjecture, neither will I come up with any ill doing or wrongdoing on the part of the Court of Appeal.
If I flip the table now, if I turn the tables and you were to be on the other side, going for the Supreme Court, going to the Supreme Court, what will be your argument against the unanimous decision of the 5 justices on this particular matter?
You know, like we normally say, once a matter is before the Supreme Court, it will be foolhardy for us to sit back and begin to articulate or once the Supreme Court, you see, well, the reason why we're doing all of this is because the Court of Appeal has determined it. And we're analyzing the decision of the Court of Appeal. What the Supreme Court will do will be based on, you know, the Supreme Court is a court of justice, and it is the apex court. I like the way Mr. Zekome put it. Once the Supreme Court determines it, that is the end.
They cannot reverse themselves.
You can't reverse them. So you can't go on appeal. The only appeal that you then have is probably to assemble a group of prayer warriors to pray for some change to take effect. But once the Supreme Court pronounces, that's the end. But for me, looking at it this way, first and foremost, was it done in compliance with the Electoral Act? There are a number of sections in the Electoral Act that plays out in relation to the judgment of the Court of Appeal. So if it has been done within that ambit and it is taken to the Supreme Court will also look at it within the ambit of the law, within the confine of the law, to determine if the decision, mind you, tribunal, you have 3 judges, appeal, you have 5 justices, Supreme Court, you then now have 7. Now, if 5, right, are in total agreement in relation to this issue, by the time it gets to the Supreme Court, plus or minus, you might have the 7 agreeing, or you might have maybe 1 or 2 dissenting. How it will turn out, for me, looking at the law the way it is, I don't see how it can be reversed.
I'm just wondering, though, sorry, Chamberlain, looking at the protests that have greeted this, the judgment of the appeal court, do you think that sometimes courts wonder what will be the outcome, the political outcome of certain judgments that they give?
Certainly. I'll give you an example. I remember the governorship appeal of the incumbent governor of Ondo State sometime back. The chairman of the tribunal, after he made the pronouncement, he said even from the response of the people that came to court showed the popularity of the governor at that time. I don't know about now. Now, because they take a lot of things into, because they're also human beings. But he said the law is a law. But in the case of Abia, it's a bit funny, in the sense that some people engineered or orchestrated or inspired or encouraged the appellant, that's Dr.
Alex Oti.
Dr. Oti, to go on appeal. And because I also saw it on TV, when the judgment was delivered, there was some jubilation and uproar in the entire state. And then suddenly, because you see, you have 2 sides. There are two major political parties in the state. Some will be aggrieved, and it goes beyond, this will not take all syndrome has to be dealt with in this part of the world. Some people will suddenly feel that whatever perks of office that they were enjoying in the past, you remember that when Jonathan threw in the towel and called President Buhari, that he was conceding defeat. Some people were not comfortable. Some were actually angry. That why would you do such a thing? You understand? Now, if, for instance, the incumbent governor calls his contender and wishes him well, the matter has ended.
But in terms of interpreting those reactions in Abia State and maybe beyond, could it be that, what if, because people look at it from different perspectives, if one says those who rejoiced on that day, clearly they were elated and so couldn't contain their joy, they went on and celebrated, and that's what you saw on TV. And then those who lost, maybe in shock, couldn't come to terms with it, so it took them a while before they got themselves back.
Delayed response.
He delayed response and then hit the streets eventually. So if they look at it from that way, could it be that both protests, how would the court see it, if at all they look at what happens or the effect of the judgment?
I see, while you were talking, I was just reflecting on justice. If you see the maiden of justice, there's a blindfold. What does that mean? Dispense justice without fear or favor. You can't be influenced. You don't look at no sentiments.
But they can hear.
Yeah, you can hear, but the fact is what is placed before the court. The court can only pronounce on facts before it, in addition to the law. Sometimes judges are also helpless. You can see a clear case, right? And at the end of the day, a case that should have turned out positively it gets a negative pronouncement. Why? It's either the lawyer or because dearth of evidence and a number of other factors. And they are also helpless. But they cannot be seen. Part of our position is that the court will not condescend into the arena of conflict. The court must be seen to be neutral.
The CJN has been speaking on this particular one now. We're talking more broadly concerning judgments. You go to State A and you look at the argument that has led to that particular judgment. It's not the same outcome that you get when you go to State B. And even in the case of some of the local government and assemblies, National Assembly elections we also talked about, you would have noticed that it's also affected some other states, while some other states it's a different ball game. How do we streamline all of this? When we say the court is one, and you hear some kind of discordant tunes concerning judgments, does it affect you?
So definitely, you see, we're in total agreement with the position of this Chief Justice of Nigeria when he made that statement. And he went further in advising particularly the Court of Appeal as to what to do. There's need for regular conferences, regular interface of the various divisional heads of the court to sit down together and x-ray, discuss, and analyze judgment from the different divisions. I'll give you in other developed climes, some African countries, your appeal will not go beyond the Court of Appeal, particularly on an issue that is settled. You can only go to the Supreme Court where you can show that the issue that you're articulating or you want to advance or argue is an area that has not been pronounced upon. Only that ground will allow you, and then you must put it by way of a brief. The challenge we have today, I hope you are aware that before now, governorship election petitions didn't go beyond the Court of Appeal. After the Tribunal Court of Appeal was the final court. And then in the last 4 years, because of what happened in the Sokoto election under Bafarawa or so, the system changed, and then the law was then amended because of some political consideration. I think we need to go back to that old order. A situation where, whilst I consider section, I think 143 or so of the Electoral Act that simply says that the incumbent remains in office until the election is determined one way or the other. Now, as we speak, the governor of Abia State will remain in office until the Supreme Court determines the election one way or the other. But in the past, once the election tribunal finishes, that's the end. I remember once on this program where I said, our challenge really is this. If at the end of the day the court nullifies the election, what then happens to third-party rights that have been created? What happens to the funds that have been expended?
You know, one other thing that was raised there, the defendants did say they raised objection about the constitution of the panel the Court of Appeal. But the Court of Appeal overruled that and then say no, they were rightly constituted. Well, some have said in some cases, if certain things are raised, they just hand back the case file. But in this case, could the same thing have happened?
Well, it depends. If the court first has to determine if whether it is properly constituted or not. I've been in cases where a particular judge who handled a matter in the High Court has now been elevated to the Court of Appeal, and we appeared before the court and we cited this particular judge without even making it an issue. The court itself said there's no way we can hear this matter because one of us was in the High Court when this matter was argued. So for that reason, it was adjourned for the court to be properly constituted. Because sometimes there are also political flags that we also fly. You understand? Because for some reason, some people get there, you perceive that a judge will probably have some lineage or some weakness towards a particular political party. So for that reason, you raise it without substantiating it, without any evidence. Some instances, some issues that are raised before the court are also contemptuous. And I think the time has come for us to begin to address some of these issues.
You know, about the fact that at the declaration of the results, that part where INEC, even if they see that there's overvoting or something goes wrong, they can't change it. I mean, while we covered those elections, we had a lot of people who called in. Some say, look, I'm calling from the spot where this is going on. I'm looking at the documents. This is not right. Then we call INEC. They'll tell you, well, we've investigated. If they want to challenge it, go to court.
Right.
Isn't it about time that something be done about those kind of cases, rather than wait for us to complete a system that we know, assuming it's wrong, you go on with it, and then you go to tribunal?
No, except the act is amended. But you see, Nigeria is also a very strange environment. If you give the power to INEC, because INEC some years back was also a political institution, at the end of the day, what you then now see is INEC will toe the line of the ruling party, and is by its name independent. So its independence or neutrality cannot be guaranteed, except the law is amended to do that. But again, there are a number of factors that you also take into consideration. So it's best for the court as the neutral or constitutionally empowered umpire to determine the case.
And the thing about this case is when they get to Supreme Court, most of them don't take time. It could be given in quick time.
Yeah, because the law says 60 days. The law is clear, 60 days within which to determine the judgment must be out within 60 days.
Sorry, when does the 60 days start counting?
From the date...
First instance?
Yes, from the date the pronouncement was made.
Pronouncement was made at the appeal? At
the appeal court. From the day the judgment was delivered, you have, I think, 21 days within which to file your appeal, 60 days for the court to do. Everything must be done within 60 days.
Cool. Interesting. Well, Mr. Nelson Quakers is a senior advocate of Nigeria. Thank you for coming on today.
My pleasure.
We'll be back in just a moment. We have just one more thing to focus on. Don't go away yet.